What I want to do with you in the next several minutes is to talk about a pair of topics that will come up on the exam that were not covered in the regular torts lecture. And these two topics are the laws of defamation and privacy. Let me say at the very outset, of the two, defamation is clearly the more important. And defamation law has a number of bits and pieces that I want to make sure that you're comfortable with. When we approach it, I want to start with the basic common law cause of action. That cause of action has three elements. I'm going to do them one by one so that we don't lose track of them. The first element is that the plaintiff must show that the defendant made a defamatory statement that specifically identifies the plaintiff. Element number one, you got to show that the defendant made a defamatory statement that specifically identifies the plaintiff. Obviously, there are two different parts there. I guess we could call it 1A and 1B. 1A, what do we mean by a defamatory statement? It's not very helpful to define defamation as a defamatory statement. That sounds kind of circular. Well, a defamatory statement is defined as a statement which tends to adversely affect your reputation. It is a statement that tends to adversely affect reputation. Some courts define it as a statement that will lower the subject of the statement, lower the subject in the estimation of the community, or deter third persons from associating with that person. I think one good way to think about all that is to appreciate that for quite a long period of time, the law viewed your reputation as an economically valuable asset. It wasn't about your emotions. It was about your ability to go out into the marketplace. Your reputation was what enabled you to get a job. Your reputation for competence, your reputation for honesty was what led people to hire you. That same reputation would lead people to deal with you, for instance, to enter into transactions or contracts with you. If you are a professional, that reputation would cause people to hire you for your services, to retain you, perhaps as a lawyer. Your reputation was a valuable commodity that you could monetize, to use the online 21st century language. And the tort of defamation was principally about remedying situations where somebody took that valuable asset and they damaged the asset. It's as if they took an object that belonged to you and scratched it up. And what they're doing now is they're scratching your reputation. So a defamatory statement is a statement that tends to adversely affect reputation, lower you in the estimation of the community. But I think that that is still too abstract. As a practical matter, a defamation case usually involves an allegation of fact. It usually involves a factual representation that reflects adversely on some trait of character. That's what we typically find. So the statement that Pete is embezzling money from the company where he works purports to be factual. It sounds like it's a statement about the real world. It is susceptible to a true-false analysis. Pete is embezzling money from the company where he works, and it tends to adversely reflect on his character for honesty. Honest people don't steal from their employers. The statement, Dr. Paul killed 3 people during the course of surgery in the last month, purports to be a factual statement. It is susceptible to a true-false analysis. And that statement adversely reflects on the doctor's competence. The statement, Patrick is a child molester, or Patrick is making counterfeit money, or Patrick files false income tax returns. These are all statements that are susceptible to true-false analysis, and these all reflect negatively on morality, in the sense that if you're a child molester, you're behaving in ways that contravene the morals of the community, or if you're engaged in income tax fraud, you're behaving in what we might say is an immoral way. So that's what we're looking for. A statement is defamatory if it's purportedly factual in nature and if it reflects negatively on a particular character trait. Now, every now and then, we have had litigation over statements of opinion. The general view is that a statement of opinion is not defamatory because it is not subject to this true-false test. If I say I don't like coffee, I mean, we can attempt to determine whether I'm telling the truth, but if I say to you, in my opinion, coffee is not tasty, again, I mean, that's not something that is susceptible to some kind of empirical test. That's my opinion. So the law has emerged that in defamation litigation, a statement is only defamatory if, as an opinion, it implies an underlying factual basis. If you make a statement in the form of an opinion, but it implies fact, then that could be defamatory as well. So if I say, in my opinion, you'd be crazy to let Attorney Jones handle your escrow money, and you know that I retained Attorney Jones in a real estate transaction last year, that statement of opinion has the inference that it is based on fact. That seems like a coded way of saying he stole money from me. So if the statement has that underlying factual representation, sure, it can be defamatory. But if it's pure opinion, I think that the Alpha Steakhouse is better than the Omega Steakhouse, that is not the kind of thing that could be defamatory. One thing that we know for certain is not defamatory is mere name calling. Calling somebody a no-good son of a bitch is not defamatory. It has no factual content. Again, it can't be subject to that true-false test, using all kinds of vulgar language. So that really doesn't count as defamatory either. Now, I have to say that most of the time, the defamatory nature of the statement that they give you on the exam is usually pretty self-evident. When they give you a statement that says somebody is a child molester, when they give you a statement that says somebody is a habitual drunk, when they give you a statement that somebody is an embezzler, you don't have to agonize over it. Now, as I indicated, the statement must also specifically identify the plaintiff. It must specifically identify the plaintiff, but it does not actually have to use the plaintiff's name. Any other identifying information in the statement is sufficient. So if I say the U.S. Attorney for the Eastern District of New York is destroying evidence in several of the cases that that office is handling, that specifically identifies an individual because there's only one person who is the U.S. Attorney for the Eastern District of New York. So element number one, pretty straightforward. We need a defamatory statement that specifically identifies the plaintiff. There is one final thought that I will share with you. The plaintiff must be alive at the time that the statement is made. Once you are deceased, you obviously no longer have any interest in making economic use of your reputation. You're not exactly going on job interviews after you're dead. And so the person has to be alive at the time the statement is made. What that effectively means is that you can say anything you like about someone who's deceased without any fear of litigation. Let's talk about element number two. Element number two is that it is not enough that the statement be made, there also must be a publication of the statement. The statement must be published. But in this regard, we're dealing with another one of those words that doesn't mean the same thing in the law as it does in everyday speech. In order to illustrate the idea of publication, let me give you an example. I want you to imagine that I asked one person to please remain in the room after we finish the lecture. So we get to the end of the lecture. I'm alone in the room with the one person, and I said, let me tell you why I wanted you to stay. I've been looking at you the whole time we've been here, and I'm pretty observant. I notice things about people. And what I wanted to tell you is, what I wanted to tell you is that you have syphilis. That's what I want to tell you. I could see that by looking at you. It looks pretty bad. You should get that taken care of. Okay? What I want to ask you is whether or not that exchange has any tendency to adversely affect the reputation of the person I am talking to. The answer is no. And the reason is because your reputation is, by definition, what other people think of you. If I say nasty things about you to you alone in private, I may hurt your feelings, but literally as a matter of dictionary definition, I can't hurt your reputation. There is no reputational harm there. So what does that mean? Well, that means that in order to begin chipping away at your reputation, I must share the statement with others besides you, the plaintiff. But the rule is a de minimis rule. Publication is satisfied if I share the statement with one other person. In my example, I want you to imagine that a second person returns to the classroom. A second person returns, comes in because person number two has forgotten a book. Person number two comes into the room and I say, hey, come here, have a look. Syphilis. That's publication. That is enough to begin chipping away at reputation. Now, your common sense will tell you, the more people the defendant shares the statement with, the more reputational harm there will be. And that is reflected in the damage award. When you sue, you are likely to recover more money for a statement that was cast broadly about in society, maybe put in the newspapers, than you would be for a statement that was only whispered to 2 or 3 other people. But the testable mechanical point is that if the statement was made to the plaintiff and the plaintiff only in private, it's not published and there can be no cause of action. One additional thought about this publication requirement. Publication doesn't even have to be intentional. A negligent publication is sufficient to satisfy this element as well. A negligent publication is sufficient. I want you to imagine that a supervisor calls a subordinate employee and says, John, could you come down to my office? John comes to the office and the supervisor said, close the door. So John closes the door and the supervisor says, John, I've been reviewing your expense accounts. It appears that you've been lying on your expense accounts and you are trying to steal money from the company. But the supervisor has carelessly left an intercom button in the on position. And the administrative assistant sitting outside, the administrative assistant is able to hear the whole conversation. That counts as publication. That's publication, even though it was careless. Finally, every person who repeats a defamatory statement is also subject to liability. They are all considered to be republishers. So if Al tells Bill that John has syphilis, and Bill tells Carl, I heard from Al that John has syphilis, and they keep repeating it, each one in the chain can be liable as a so-called republisher. The third and final element of the defamation tort is the element of damages. The element of damages, however, is not always a required proof element. There are a number of cases where damages will be presumed. And in order to know which cases those are, we have to slice and dice the law of defamation. The first subdivision of the law of defamation is called libel. That's spelled L-I-B-E-L. A libel is any defamation that is embodied in permanent form, usually written down, printed, but it could be tape recorded or stored on a hard drive. In libel, no damages need to be proved. Damages are presumed under the law of libel, and that means that you don't have to offer any damage evidence. You can get to the jury with only two elements. But let me state the obvious. The more you prove, the more you get. If you take advantage of this rule and you only offer evidence of the statement and its publication, the jury may say, yep, that's definitely a libel case. Here's $10. So it's to your interest as a litigant to prove damages if you have them. All I'm saying is that no directed verdict will be entered against you if you opt not to put on any evidence concerning damages in a libel case. Now, the other type of defamation that we encounter is called slander. Slander involves a defamatory statement that is spoken or oral in nature. Slander is actually further subdivided into two groups. The first group are called slander per se, a Latin phrase, P-E-R-S-E. Slander per se gets the same presumed damage treatment as libel. Slander per se, presumed damage, just like libel. The question is, what do we mean by slander per se? Well, this is defined categorically. There are four specific topical types of statements that constitute a slander per se. Let me just march through this list with you. They're not particularly complicated. The first is any statement relating to the plaintiff's business or profession. Any statement relating to the plaintiff's business or profession is slander per se. So the statement that Dr. Paul killed 3 people in the course of surgeries over the past month, if spoken out loud and not committed to writing, that would be slander, but it would be slander per se because it is related to his business and occupation, namely his work as a surgeon, and therefore he would not have to prove damages to get to the jury. Second category would be a statement that the plaintiff has committed a serious crime. The statement that Patrick is a child molester is a statement that would fall within slander per se, because being a child molester is, among other things, in addition to being reprehensible, a very serious criminal offense. Now, the line between a serious crime and a not so serious crime is one of those fuzzy lines in the law. The statement that John smokes a joint every now and then is obviously not slander per se, even in a jurisdiction where marijuana remains illegal. That's not a serious crime. The statement that Mary litters, she throws bubblegum wrappers on the ground, is not a serious crime. If the crime involves honesty or violence, it's a serious crime. Perjury, securities fraud, arson, rape, murder, these are all obviously serious crimes. Category number 3. Category number 3 is a statement that imputes unchastity to a woman. A statement imputing unchastity to a woman. This is old-fashioned language. This is pretty much rhetoric that we get from Victorian England. What we're talking about here is any statement that suggests that an unmarried woman is sexually active. Any statement that suggests that an unmarried woman is sexually active. So the statement that Mary and her boyfriend are sharing an apartment and sleep in the same bed and have sex. that is slander per se. Now, a lot of people are like, really? Still? In this day and age? And the answer is yes, still this day and age. It's obviously up to the plaintiff to decide whether to bring suit, but there are still many people who either as a matter of personal and private morality or as a matter of religious belief don't think that sex before marriage is appropriate, and who would feel that their reputation had been damaged if it were said about them that they were engaging in that behavior. The curiosity here, and frankly the sexism here, is that it only applies to women. It only applies to women. A statement imputing unchastity to a man is not slander per se. It could be slander, but not slander per se. The statement that John is sleeping with his girlfriend unmarried and having sexual relations, that is not slander per se. And that takes me to the fourth and final one on this list, which is my personal favorite, a statement that the plaintiff suffers from a loathsome disease. The plaintiff suffers from a loathsome disease. That's a disease that when you have the disease, other people loathe you. And I know you're wondering what diseases those may be. There are only two. The first, these are very old rules. The first, leprosy. Leprosy. If you say John is a leper, Mary lives in a leper colony, that is slander per se. And I've been doing bar review for a very long time. They give this exam twice a year. I have never, ever seen a leprosy question. If you get it, call me, tell me. I'd really be excited to hear that. But now you know. The other loathsome disease is venereal disease. And that's why I used the syphilis example when we talked about publication just a sec ago. And there have been very infrequent questions about venereal disease and its status as slander per se. Somebody asked me a couple of years back, they said, well, how will I know that the disease that is mentioned is in fact a venereal disease? Okay, really? First, let me put your mind at ease. First of all, if my memory serves, when they have asked about this, they don't name a particular disease. They just say, Dave was giving a speech about his political opponent, and he said his political opponent had a venereal disease. So you don't have to analyze the disease. But if they give you a disease, for goodness sakes, it is going to be one of the marquee venereal diseases. It's not going to be some subtle, new, exotic VD that you never heard of. It's going to be syphilis or gonorrhea, right? They're not going to trot out some obscure, newly emergent strain that you're unlikely to be able to identify. This is not the OBGYN medical board exam, for goodness sake. So don't look for things to worry about. That is not a thing to worry about. Now, as I said, if you fall into one of the four categories of slander per se, or if you have libel, you don't need to prove damages. It's presumed. If you have slander not per se, then you must prove damages. What would be an example of a slander not per se? Well, a statement that a man is engaged in premarital sex or maybe extramarital sex. The statement that John is cheating on his wife or the statement that John is promiscuous. These would be slander, at least potentially slander, might call him into disrepute or lower him in the estimation of his community, but they wouldn't be per se. In order to recover in that kind of a case, you actually have to offer evidence of damage. And when we say damage, what we mean is economic harm. What we mean is you lost a job or you got fired. You were trying to get a job and you didn't get hired, or you got fired because people heard these rumors about that you were promiscuous. We mean you lost a contract. We mean revenues are down at your place of business. It has to be something that is grounded in the world of work and the world of money. Hurt feelings do not count. This is not supposed to be about emotional injury. The fact that because of the slander, you're not invited to any nice dinner parties anymore. The fact that because of the slander, you've been thrown off the bowling team. The fact that because of the slander, When mothers with their young children see you passing by on the street, they cover their children's eyes, so they shouldn't look upon you because you're so disgraceful. That doesn't count. It's got to be an economic harm. Now, in some states, we have different rules about this. In some states, we don't follow this same pattern. There's a little bit of mix and match. So let me give you some of these distinctions in case you happen to be headed to these states. In Michigan and in Virginia, libel and slander are treated the same, so that you only get presumed damages for libel if the libel falls within one of the four magic categories: business or profession, serious crime, unchastity of a woman, or loathsome disease. Any other libel, you would have to prove damages, just like any other slander. So, in effect, the categories in the states of Michigan and Virginia are per se and not per se, regardless of whether it's libel or slander. Florida does the traditional thing, but Florida has a sort of, I don't want to say unique, but a slightly different approach to this. In Florida, if the defendant is a media corporation, a TV station, a radio station, a newspaper, there can never be presumed damages. You always have to prove actual damages if you're suing the media. So that doesn't matter. Obviously, in many cases with the media, in almost all cases with the media, it's libel, because the media either prints and permanently disseminates or tapes most of what it does. But even if it were not recorded, it doesn't matter. You do not get the benefit of presumed damages. You always have to prove damages in Florida against a media defendant. Okay? So let's see if you can process what I've done so far. I want to just give you a quick little question, and maybe you can sort of apply this, as I like to say, in the format of a one-sentence micro essay. Two women who are both parents of young children are standing out in front of a school. I will call them Debbie and Jane. And they're waiting for their kids. They're waiting for the school to dismiss the children. And Jane says to Debbie, I wonder if I could get the phone number of your child care person. I understand that you have a child care person, and I wonder if I could get her number because I'm looking for a person as well. Debbie knows that it's very hard to get good child care, and she knows that the lady who works for her is excellent, and she's concerned that Jane will lure her away at a higher wage. So Debbie says to Jane, you don't want her number. I mean, really, you don't want her number because we discovered that she was drunk last week when we came home from work. Well, this is entirely inaccurate. There was no such episode. This was just what Debbie said to get Jane off of her quest for the phone number. But having heard it, Jane repeated it to a number of other people, and it was suddenly widely circulated. And the child care employee, I'll call her Pamela, learns of it and sues Debbie for defamation. She says, you made this statement about me, I'm suing you for defamation. And she establishes all of the facts I just gave you. Which of the following additional facts will she have to prove in order to succeed? I'm doing this as multiple choice, okay? So it's not really micro essay, but first, that she suffered special damages by reason of Debbie's statement. Second, that she lost other child care jobs as a result of the statement. Third, or C, that the statement was extreme and outrageous because drinking or any use of alcohol is against Pamela's personal moral beliefs. Or D, no additional facts need be shown. So Basic facts as you have them. What additional facts need to be shown? Does she have to show special damages? Does she have to show that she lost additional jobs? Does she have to show that the conduct was extreme and outrageous? Or is she not obligated to show anything else at all? A or B or C or D? The answer should be D. She does not really need to show anything else here. The statement in question is slander. It was not written down, it was spoken. But it was a statement that relates to her business or profession. Being intoxicated while you're in charge of young children obviously suggests unfitness for your job. So in that sense, this would be slander per se. In slander per se, damages are presumed. There is no obligation to show she lost other jobs. That would be economic harm. There was no obligation to show any special damages. A and B are wrong. Extreme and outrageous conduct would be relevant if she were suing for intentional infliction of emotional distress, but not relevant in a claim for defamation. Basically, without any additional facts, Pamela, the child care worker, has a sufficient case. All right, there you have it. That's your defamation tort. What about affirmative defenses? Well, there are 3 affirmative defenses, but the first 2 I will dispose of in one sentence each. Number 1, consent. We've covered consent in the main torts lectures. If you go back to your module on intentional torts, it's there. Consent can be expressed, it can be implied. It's a defense to defamation if it comes up. Defense number 2, truth. The expression disembodied from context, truth is a defense, is something that you probably heard long before you even got to law school. In this context, it essentially means that the defendant can show that the statement is factually accurate, and that defeats the claim. The defendant can always come to court and say, but you really are embezzling money from your company. You really did kill 3 people in surgery. You really are a child molester. You really do have syphilis. You really were intoxicated while you were taking care of my kids. Show that, and there can be no liability. Just bear in mind the burden of proof will be with defendant because it's an affirmative defense. Defense number 3 is what we call privilege. And there are 2 kinds of privilege. The first is absolute privilege. Absolute privilege is based on the identity of the defendant, the category or the nature of who the defendant is. And there are only 2 that I want you to worry about. The first absolute privilege is for communication between spouses. You come home from work and you tell your spouse, my boss is stealing from the company. My coworker is habitually drunk at work. These statements would normally be actionable. These statements would be slander per se. These statements are published because you're revealing them to someone other than the plaintiff. But because you're talking to your spouse, absolute privilege. You can say whatever you want to your spouse. It's a good, look, the law takes the view that you should be uninhibited in talking to this one person who is supposed to be your lifelong companion and your best friend. And the law doesn't want to meddle or interfere or turn one spouse against the other as a witness. So I think it's a good rule, right? I think it's a rule of practical necessity. Think about it. If in speaking with your spouse, you couldn't defame the neighbors, what the hell else would you talk about? This is what keeps your marriage fresh, all right? So it's a good rule. The other absolute privilege is for officers of the 3 branches of the government in the conduct of their official work. Officers of the 3 branches of the government, executive, legislative, and judicial. The most important application of that second absolute privilege is in the judicial branch. In the judicial branch, the privilege is extended not just to the judge, it is extended as well to the lawyers and the witnesses. So that's an important thing, and it's a good thing to know as a practicing lawyer, even if you don't practice tort law. Because it means that anything you put in court papers, anything you put in a brief, a memorandum of points and authorities, motion papers or a pleading, and anything you say in open court while arguing a motion or an appeal or making a closing argument in front of a jury cannot be the subject of a defamation lawsuit. You are clothed with an absolute privilege. But as I said, this covers all the branches of the government. So if a city council member says something in the course of a public hearing of the city council, that's absolutely privileged. If a United States senator says something on the floor of the Senate, absolutely privileged. If the Secretary of Agriculture says something in congressional testimony, that's absolutely privileged. And that takes me to the other kind of privilege, which is probably more testable, and that is the qualified privilege. Qualified privilege arises only when there is a public interest in encouraging candor. A public interest in encouraging candor. The situations where that is true are decided on a case-by-case basis. But to make it a little bit concrete, I want to give you at least two solid examples. The first is references and recommendations. There are a number of cases where people seek references and recommendations. If you're only recently out of law school, your mind may turn immediately to the academic context, where you ask an instructor for a letter that might go to an employer. But obviously, there are many other kinds of references. You might ask a former employer for a reference. But if you're applying for a loan, you might ask for references from people who've lent you money in the past. If you're applying for an apartment, you might ask your previous landlord to vouch for the fact that you're a good tenant. Now, all of this recommending is only valuable if it's accurate and honest. What good is getting a reference concerning somebody's status as a former tenant if it's not truthful? So we want to encourage people to speak truthfully, but they may feel nervous about it because they may think they're going to get sued. So in order to encourage them to speak truthfully, you know what we do? We clothe them with a qualified privilege. We say to them, we've got your back. You can say in this letter of recommendation, this person is very bright, but sometimes their work gets a little sloppy, and you don't have to worry about getting sued. But the privilege is qualified by two conditions. Number one, the person invoking the privilege must have a reasonable and good faith basis for making the statement. You need a reasonable and good faith basis. You can't expect to have a privilege if you deliberately tell lies, if you just, to be blunt, make crap up. If you just put things into a letter of recommendation that are fictional, that you know to be fictional, or that are wild speculation, you don't get the privilege. You have to be making what I'm going to call an honest mistake. It has to be an honest mistake. Second condition, you also must confine yourself to matters that are relevant to the subject at hand. You can't go off on tangents. Student comes to me and says, Professor Schechter, would you be kind enough to do me a letter of recommendation for a clerkship? I just heard about a new judge that got confirmed, and I don't think this judge has hired any clerks. I think I may have a shot. And so I'm like, absolutely, I'll get right on it. I fire up my word processor and I start to type. Dear Judge Smith, I understand that Sarah Jones has applied to serve as your law clerk. I'm so happy to have the opportunity to say a few words on her behalf. She's quite extraordinary and would make a superb clerk. paragraph. Sarah was a student in my torts class, and she spoke up often in class, always to good effect. She thinks quickly, expresses herself admirably, and has a keen understanding of the deep nature of tort law and policy. Paragraph. In addition, I think you'll find Sarah a congenial person. She always has a smile on her face, she always seems in a great mood, and she always seems ready for business. Period. Paragraph. However, I think you should know that Sarah has leprosy. What the hell is that? That doesn't get that out of the letter. That's a bit extraneous. We don't need to put that in the letter. And so I would lose the privilege for that. So long as you speak in good faith and confine yourself to relevant material, you will be protected by the qualified. So there you go. You got three elements. You got three defenses. You might think we're done. We're not done. There is a special scenario in the law of defamation. If you study this in law school, you will recognize this. If the subject of the defendant's statement is a matter of public concern, then we have some additional rules. If it is a matter of public concern. So the first question you're going to have is, well, how do I know if it's a matter of public concern? And the answer is, I can't help you because the courts have not come up with a definitive test. Indeed, they have been very explicit about saying, gee, that's a hard question. Obviously, what we mean is something that is newsworthy, something in which there is widespread public interest, something in which there is likely to be a public discourse. Certainly, anything involving the honesty and integrity of public officials is a matter of public concern. Is the mayor taking bribes? Is the head of the CIA actually a double agent selling out American secrets to our political and military adversaries? Other matters of public concern might concern celebrities or sports figures and the integrity of what they do. So, for instance, it might be a matter of public concern that a particular athlete is taking performance-enhancing drugs. It might be a matter of public concern that a particular singer is about to terminate abruptly a relationship with a record company. These might be matters of public concern. You'll know it when you see it, and it won't be subtle because the examiners appreciate that there isn't a test. And so you'll know it's going to be a big deal subject. If it is a matter of public concern, we want to make sure that people are not intimidated from speaking freely. So what we do is we add two additional elements to plaintiff's case. We make it harder for plaintiffs to win. Number one, the plaintiff must, in a public concern case, prove falsity of the statement. Falsity. Now, you will recall, since I said it only a couple of seconds ago, that truth is a defense. What we're doing here is we're moving the issue of the accuracy of the statement off of the defendant's shoulders and moving it to the plaintiff's side of the lawsuit. The plaintiff is now the one who must come forward with evidence of falsity. Newspaper publishes a story. Mayor is taking bribes. The mayor sues the newspaper. The mayor says that's libel. That's a matter of public concern. Do we have an honest mayor, or is he crooked? In that case, the mayor must prove that he's not taking bribes, that the statement the newspaper made is false and inaccurate. By the way, proving a negative, not so easy. How do you prove that you're not taking bribes? Prove to me that you didn't take a bribe today. How do you prove that? That's kind of hard. But that burden is on the plaintiff. Second thing the plaintiff has to show in a public concern case, the plaintiff has to show some degree of fault. Fault in the defamation context means that the statement was made other than in good faith. It was made in bad faith. It was not a good faith statement. But there are degrees or gradations of fault. And the degree of fault that you have to show depends on who you are. If you are a public figure, then you must show that the statement was made knowing that it was false or with reckless disregard of its truth or falsity. You know that it's false or reckless disregard of its truth or falsity. That is sometimes referred to as malice. The statement was made with malice. So, mayor is suing the newspaper. Newspaper said mayor is taking bribes. The mayor has to show, first, I'm not taking bribes. Second, you knew that I was not taking bribes and you published it anyway. You just fabricated it and you made up a lie about me to hurt me. Or you behaved recklessly. And what would reckless be in this context? Well, a reporter was walking into the newspaper's office building one morning, and there was a drunk guy on the street. And the drunk guy said, "Hey, buddy, you work for the newspaper?" And the reporter said, "Yes, I do." And the drunk guy said, "Well, the mayor is taking bribes." And the newspaper reporter runs upstairs and says, "Let's run with it. I have a scoop." No checking, no verification, just relying on the word of a drunk. That would be reckless. If the plaintiff is a private figure in a public concern case, it is enough to show that the statement was made negligently. Failure to exercise reasonable effort to confirm its truth. It was made negligently. If you're not someone who studied defamation in law school, there is one further thing I should probably say. You might be thinking, whoa, I don't understand how I could have a private figure wind up as the plaintiff in a public concern case. So let me explain, because it's pretty easy. Obviously, the central figure in a public concern case may be a public figure, but there may be all kinds of other collateral people who will be mentioned. Mayor is taking bribes, the headline reads. Fifth paragraph of the story. The mayor's secretary, Pamela Johnson, assisted in this crooked scheme by shredding documents for the mayor. The mayor's secretary, Pamela Johnson, is not a public figure, but the overarching story is a matter of public concern. If Pamela sues, she can win by showing negligence. If the mayor sues, he has to show malice, reckless or intentional falsehood. Now, the law that I just described to you comes from a line of Supreme Court cases, starting with New York Times against Sullivan, a very famous case. Some states decided that the New York Times against Sullivan requirements should apply in all defamation cases. In other words, every defamation plaintiff should be obligated to prove falsity, and every defamation plaintiff should be obligated to prove at least some degree of fault, usually negligence. Among the states that do that, the state of Massachusetts. All plaintiffs must prove falsity and fault. The state of Michigan. All plaintiffs must prove falsity and fault. Ohio. Virginia. So if you're taking the exam in one of those states, pretty much the special case is not special. The special case becomes every case. If you're taking the exam elsewhere, if you're taking a UBE exam, then only apply these extra elements if, in fact, it is public concern. I think that liberates us to turn our attention to the law of property. Property? No, God, no. I don't know anything about property. Let's turn our attention to the law of privacy. The property lecturer would probably be amused by that. Let's turn our attention to the law of privacy. Privacy is a heavily regulated statutory field, but when we take it up for the bar exam, we are looking at the common law of privacy. And the common law of privacy is basically an umbrella term for 4 very small torts. So our only job is to look at these 4 torts. And for each of them, I'm not going to give you elements. They don't warrant it. I'm going to give you 1-sentence definition, quick example, and maybe an exam caution. So here we go. First privacy cause of action is called appropriation. Definition. The defendant uses plaintiff's name or image for a commercial purpose. The plaintiff, name or image for a commercial purpose. Example, cereal company puts the picture of a professional athlete on a cereal box in order to sell more product. They don't ask for permission, they just do it. That's a tort. I used to be more specific and name a particular professional athlete, and I had the worst luck. Every professional athlete I would name, as soon as I used the example, they got into some scandal. So I stopped naming specific professional athletes, and I just say generically, okay? There are two things that I would warn you about in terms of exam taking on this one, neither of which is particularly momentous. Number one, there is a newsworthiness exception. It is a tort to take a professional athlete's picture and put that picture on a cereal box, but it is not a tort to put that picture on the front page of the sports section of the local newspaper, particularly if that athlete has done something that is newsworthy. Won a trophy of some kind, hit the winning home run in a World Series game, or whatever it may be. Second, while most of the actual litigated cases involve celebrities, famous folk, this tort applies to everyone in the world, you and me included. Let's say you're walking down the street and somebody surreptitiously takes your picture. You don't even know they did it. And then they put that picture up on billboards all over the city. They say, you want beautiful flowing hair like this? Buy Acme brand shampoo. They think you just had the look. You will have a cause of action against them, that cause of action for appropriating your image for commercial purposes, even though you're not a model or a celebrity or an actress or anybody else in the public eye. Tort number two. This one is called intrusion. Intrusion is an invasion of the plaintiff's seclusion. Invasion of the plaintiff's seclusion in a way that would be highly offensive to a reasonable person. Invading seclusion in a highly offensive way as measured by a reasonable person standard. What I mean by this, examples, eavesdropping, wiretapping, intercepting your emails, planting secret cameras in your home, being a peeping Tom, listening at the keyhole. These are torts. The only exam caution, I hardly think it warrants the label caution, but it's built into the concept. You must be in a place where you have a reasonable expectation of privacy. If you are out in public or semi-public spaces, you don't have an expectation of privacy, so you can't complain if people are watching you or looking at you or listening to you. If you're out at a cocktail party with a friend and you say something intimate to your friend, a confidential, a secret, you can't complain if somebody overhears it. If it's all that secret, wait till you get home. You have to be in a place where there's an expectation of privacy. Normally, that's your home. For certain purposes, it might be a hotel room. For certain purposes, it might be your car. Let's talk about tort number three. Tort number three is called false light. False light is defined as the widespread dissemination of a material falsehood about plaintiff that would be highly offensive to the average person. Widespread dissemination, material falsehood, highly offensive to the average person. In English, defendants running all over town telling a big lie about the plaintiff. Running all over town telling a big lie about the plaintiff. Dave goes around town and tells 100 people that Pete is embezzling money from his company when Pete is doing no such thing. This places Pete in a false light. It mischaracterizes him, and he will have a false light invasion of privacy claim. The example of a statement about embezzlement, though, may cause you to think back to the defamation material. I use that repeatedly as a defamatory statement. And this is a good point to note. The very same conduct can be both defamatory and false light invasion of privacy. The very same statement can be both. If you bring both causes of action in the defamation claim, you recover for economic damages. Whereas in the privacy claim, you recover for emotional and dignitary damages. You recover because you feel shamed. Now, not every false light claim overlaps with defamation. The embezzlement example is an example where both claims would lie. But there are false light claims that don't overlap with defamation. For instance, I might make a false statement about your beliefs. Let's say I mischaracterize your religion. I tell 100 people that you are a devout Roman Catholic, and in fact, you're Jewish. This is not a defamatory statement because, taken alone, the statement that you are devout and a Roman Catholic does not tend to lower you in the estimation of the community. That is not a statement that adversely affects reputation. Being known as a devout Roman Catholic is an unremarkable thing in a religiously diverse country like the United States. That said, however, it places you in a false light because that is not your true faith, because I stipulated in the question that the person being described was of the Jewish religion. And so under those circumstances, there would be a cause of action, and you can understand why. It's a bit of an imposition. The person is running around talking to his friends. His friends are like, what is this? I hear you're Catholic now. He's like, no, I'm not Catholic. I'm still Jewish. And so it would be a valid cause of action. Finally, I would point out that many false light claims arise out of accidental as opposed to deliberate behavior, but they are still actionable. A lot of the cases involve erroneous use of captions with photographs that run in newspapers. Newspapers doing a story about cab drivers who rip off tourists. And they take a stock photograph of a cabbie leaning against his car smoking a cigarette with a caption, "Many cab drivers take tourists the long way around." That places the driver in that picture in a false light, and he would have a valid claim. Just for your information, if you happen to be sitting for the Florida exam, Florida does not recognize this cause of action, so you won't see it on your exam. Finally, we come to the last of the privacy torts. That would be the tort of disclosure. This is widespread dissemination of confidential information about the plaintiff that would be offensive to a reasonable person. Widespread dissemination of confidential information that would be offensive to the reasonable person. The examples here are your doctor's receptionist mails copies of your medical records to everyone at your law firm. Your certified public accountant mails copies of your tax return to everyone in your 300-unit condominium building. Two cautionary notes about this final cause of action. Here again, we have a newsworthiness exception. Obviously, you all have heard of the genre of journalism called investigative journalism. An investigative journalist ferrets out private facts about people and then discloses them. I don't know about you people, but when I go to the supermarket, what I do is I read the tabloids while I'm waiting to pay for my groceries. I don't ever buy them. I view it as like a free public library resource, but I read them and I catch up on the gossip. And they're filled with the disclosure of private fact. This celebrity is having an abortion. This celebrity is gay, but is trying to keep it in the closet. This other celebrity is HIV positive. This other celebrity is addicted to opioids. And how do they get away with it? It's all newsworthy. When we decided that this was all newsworthy, I don't know, but apparently it's all newsworthy. That's how they get away with it. The other exam caution is that the fact in question must be truly confidential. There are certain facts that you share with some people in your life, but not with everyone. We all tend to operate in multiple arenas. We have our work friends and colleagues. We have our family. We have our social friends. We may have a community at church. We sometimes share things in one of those arenas that we don't want moved to the other arena. But those things are not truly confidential because we've already shared them. And so in those cases, you would not have a valid disclosure cause of action. I want you to imagine that Pete is a 28-year-old gay man. He's out to his friends and his family. He's in a committed relationship. He and his partner are thinking of getting married. He's pretty active in the gay community, but he's not out at work. His company is very conservative, and for the moment, he's biding his time. He wants to see whether or not it's a prudent thing for his career to be out at work. Anyway, one weekend, he's at a gay pride rally or march, and he's holding up a sign that says, "I'm gay and I'm proud." And by coincidence, one of his coworkers walks by on the street and sees him. The coworker shows up on Monday morning and tells everyone in the office, "Oh my God, you'll never guess what I saw this weekend. Pete is gay. Pete was at this rally. He was holding a sign, 'I'm gay.'" So Pete sues for disclosure. Is he going to win? He's not going to win. He was out in public holding up a sign. It's not a confidential fact. The fact that he would have preferred to keep it secret from his colleagues at work is not going to help him. And the fact that we might think that the person who repeated the information was behaving in a bit of an inappropriate way, or more than a bit, the fact that we might think that that was sort of despicable gossiping doesn't really help either. No cause of action there. So the only thing that remains is for me to tell you about the defenses to the privacy torts. There are two, but we've done them already, so it's easy peasy. Number one, consent is a defense to all four claims. See above, no new information. Number two, the defamation privileges, absolute and qualified, are available to defeat false light and disclosure claims. The reason they're not available for the first two privacy torts is because they don't logically connect to those torts. If you think about that, you'll realize that. But absolute privilege will protect you from a claim of false light or disclosure. So if a United States House of Representative member, a U.S. congressman, is on the floor of Congress during that period when they can make random speeches, and he's like, "Mr. Speaker, I want to tell you about one of my constituents. He's a wonderful person. He's a pillar of his community. He's a devout Roman Catholic." And it turns out this constituent is Jewish. He just made widespread dissemination of a false statement. He just put that person in a false light, but he has an absolute privilege because he's a member of Congress. So that's what you need to know about defamation and privacy. I'm pleased that you were able to tune in for this special module on those topics, and I wish you all the best.